version of it, whatever that's going to be.
That's correct. Sir, what's that? All right. Prince William-Manassas leading the jail board meeting to order. Sir, could you call the roll, please?
Ms. Ashworth?
Present.
Mr. Olson?
Here.
Mr. Bailey?
Present.
Ms. Clymer? Absent. Ms.
Alternate.
Oh, I'm sorry, I didn't know that was. I don't have a.
Vic Hatcher, Captain
Okay,
Vic Hatcher.
okay. Mr. Hatcher? Ms. Guzman? She's absent. Sheriff Hill?
Here.
Chief King?
Here.
Ms. Lennox? Present. Mr. Torres?
Present.
Mr. Newsom?
Here.
Ms. Smith? Here. We have a quorum, sir.
Thank you. Thank you. Good evening, everyone. Thank you for coming. I think we have one citizen here tonight, sir. Could you please give us your name?
James Vanderhoord,
All right.
Deacon from All Saints. I just want to say thank you. We had a good orientation a couple Saturdays ago. I would have gotten very lost. Very hard to figure out where things are now. And we appreciate the opportunity to get back into mod. A couple services in the mod recently. So over time, we look forward to getting back into the.
Good. Thank you, Deacon.
Thank you, sir.
Sure.
Yes, if you want to remove the mask, you can, or certain equipment, if you want to keep it on, it's fine, it's up to individual, okay? Can I get a motion to approve the agenda from September the 15th, please?
Make a motion to approve the agenda.
Thank you, sir. Second?
Second.
Any questions? All in favor?
Aye.
Thank you, thank you. Could I get a motion to approve the minutes of the regular meeting for July the 21st?
So moved.
Second. Any questions? All in favor?
Aye.
Thank you. Superintendent?
Good evening, everybody. Thanks for coming. Sarah, did you get the modified agenda?
They should all have a copy on
Okay.
their desk for it.
Good. All right, we'll go over to page 18 to start. You can see these are our account numbers, and the second section down from the top is 536. That was for the first 2 months of FY 2022. 536 is average daily population for the complex. And the next section down below, 574, is as we look back for 1 year from now, August to September of 574 for the average. Transfers to the Department of Corrections in July was 7, August 0. Commits in July was 559, releases were 582, and processed by the ADC staff, 54. These are inmates that are brought in by the police departments. We do the processing, and the police officers can go back on the street, and the person's released by the magistrate. Commits for August 590 and releases for 590. That's a rarity. They had the same. And process only with 72 inmates by our staff. All right, on page 19, average daily population for July, as you see, was 534. And it's broken down by each individual day. And on page 20, for August, average daily population was 538. Page 21, of course, is our history all the way back to FY 1983 at 178, and shows the 2 months for FY 2022 at the top of 536. On page 22 are the objectives for FY 2022. First one is implementation of additional strategies, recruitment and hiring. You can see there the 47 current vacancy sworn staff and 9 civilian staff vacancies. The county continues to advertise their positions through NeoGov, which gets us out all over the place for advertisements, which is very important. We have seen a slowdown of applicants lately also. Prison Rape Elimination Act, we have nothing to report. Career development training, 25 staff attended Master Jail Officer refresher training. The Master Jail Officers here are the first level of the career development at the ADC. 15 staff attended Revive training, which is how to handle opioid overdoses. And 18 medical staff attended interpersonal communication. Number 4, the main jail repair project has been underway for quite some time. One side of the building is complete. The project is on schedule to be estimate completion of 9 months. The project mainly consists of replacing toilets, sinks, showers, bunks, tables, light fixtures, electrical receptacles, replacements of food slots and vents, and doing a lot of painting in the housing units, and a new roof is supposed to be coming. It's been delayed because they can't get all the materials because of COVID. They're getting them from overseas. Evidence-based decision-making policy team. The team has applied for 2 grants, looking at some assistance with data. The subcommittee for mental health and substance use has been meeting regularly and will do a mini mapping on opioid use. The circuit court is planning stages of a drug court, and the final surveys for EBDM initiative were conducted, so they should be coming in soon. COVID, update on that. On the objectives here, it says 3 staff are currently positive for COVID. Today it's 2. 4 staff have been exposed to COVID. They have all been clear as of today. So we're looking pretty good with COVID. About 63% of our staff have been vaccinated, which is good. And I'll get you the count for the inmates. The inmates count is around 243 that have been vaccinated. That includes people who have come and gone also. Actually, 326 inmates have been fully vaccinated. I'm sorry. The Spanish GED program in the mod begins on Tuesday the 21st. Richmond County Schools in the process of recruiting another teacher for Maine and Central. Mr. Chairman, that's all I have.
Thank you, Mr. Superintendent. Any questions for the superintendent concerning his report?
Yes, Mr. Chairman, I have a couple. I'll go ahead, Rob.
One question about vaccinations of the staff. Is it that 53% of the jail staff is vaccinated?
63%.
63?
Yes, sir.
Is there any particular reason why you're not at a higher percentage of vaccinated, but given the type of work that they do perform?
It's optional
Yeah.
right now. I have not forced people to get the vaccine. That could come someday, but I'm waiting for some direction through the county of what they're going to be doing and so forth. So, yes, sir.
I should have gone back and compared on the vacant staff. How does that compare to where we were 2 months ago?
It's pretty close. I think we've had about 5 more vacancies around there.
Okay.
Yeah.
And did I hear you say that you've gotten a slowdown in applicants?
That's correct.
Circuit court and planning the stages of the drug court. What is that about?
That's for inmates who are here on addiction and so forth, and they'll be coming over and maybe have some alternatives to incarceration, where they can get some treatment out in the community and monitor them through the system.
Okay.
Yes, sir.
All right. Thank you, Mr. Chairman. Those are the only questions I have.
Thank you, sir. Thank you. All right, next will be the budget objective. Carol?
On the commissary budget, we are now, after August, our balance is about 2.45 million. Very early in the year on the budget status, so not a lot of expenditures yet. So nothing to report unless you have any questions. On the next page, our federal billing, we bill about $1,000 a month. That is all to the U.S. Marshals for inmates, their inmates. We also continue to work on our payroll project to be in line with the county for January 1. I'm also working with on the reimbursement package for Phase 2 expansion to get from the Treasury Department. The package has been turned into PWC, but there's also a package that has to be turned into Treasury to accept the funds. That is for the $29 million that the county is getting, and the $687,000 that will be coming back to the agency for the work that was portion of the project. On to the operating revenues. Our inmate revenues in general are down, continue to be down because our count is down. As far as the state, we continue to get our state supported staff salary revenue, which is very helpful. The Manassas rate did go up for the first 2 months of this year. We are averaging right now 13%. We were at 10.5% for the fiscal year last year. So that's all I have. Anyone have questions?
Any questions for Carol concerning budget?
Okay, and then just on the expenditure side, nothing really to report. We are flushing out some numbers still. We went to a new financial system July 1, and so we're still working on some discrepancies, so hopefully we'll get all that straightened out. But as of right now, again, early in the year, and everything otherwise is as expected, so. Unless anyone has questions. That's all I have.
Any questions? Okay. Maybe this is for Superintendent. Carol mentioned federal inmate billing. Is there any possibility that we can do more business with the feds?
Yeah, we have, with the U.S. Marshal contract, there is a number of 20 males and 5 females, and we're going to pursue that because we do have some vacant beds. And if we have a U.S. Marshal inmate who's here on a local charge, when he gets done with his charge, we'll keep them here instead of them going to other facilities. So we'll try to produce some revenue that way, sir.
All right, thank you. Any questions on the superintendent concerning housing federal inmates? Thank you. Thank you. Well, we're moving along pretty fast tonight.
We are, I like it.
We are. And we're now with dear board members' comments. And I will start with you, Mr. Torres.
The only thing that I want to comment today is the first day of the Hispanic Heritage Month. That was both nationally and locally have been proclaimed to be the recognition of the achievements of Hispanic Americans in contributions to this country from a lot of years. And I would encourage the superintendent to find out ways to recognize Hispanic American employees that he has here at the ABC as correction officers or in other capacities. And also everybody to participate in the activities that the county will hold through this month in honor of Hispanic Americans and their contributions. The month runs from September 15th through October 15th. So it's a month of celebration for the Hispanic Americans, and they're trying to show their culture, they're trying to show their achievements, and there's enriching and the ways that they're enriching this community. So that's my comment.
Thank you, sir. Chief Musa.
No comment.
Thank you, sir. Chief?
I just want to commend Superintendent Melitas and his staff. Again, we're here with these meetings, but this jail is ran so professionally. You guys should be continuously commended for it. It's a great job.
Great staff. Thank
Yeah.
you.
Oh, no comment, sir.
Ms. Ashley.
Thank you, Sheriff.
Yes, ma'am.
I do have a motion that I would like to put in front of the jail board today to essentially bring us back to the policy that's been in effect. And I'll pass around, I have a summary. And on the back is the actual motion. It has been the policy of the jail since the recorded phone calls and such were in place to provide access to law enforcement, which up until August of 2021 included the Commonwealth Attorney's Office. Our access to the non-privileged inmate records held by the jail was stopped on August 16th officially when I received 2 letters, one from Major Lambert, the second from Colonel Melitas, stating that the Commonwealth Attorney's Office has to now get a subpoena ducis tecum to get those records. Subpoena ducis tecum is required to be, the request is required to be made through the clerk's office. The clerk's office then has to sign it, file it with the court, deliver it to the sheriff, who then delivers it to the detention center. Any electronic records that a tangible copy cannot be made must be available to all parties in the case during normal business hours at the subpoenaed person's place of employment. And it is something that any attorney can avail themselves of in a lawsuit to get the records. But the Commonwealth Attorney's Office is defined by the Code of Virginia as part of law enforcement. That is in the code that defines the powers of the local constitutional officers. And so given that definition of our office as law enforcement, the practice of providing this information to us since at least the inception of it, I would make a motion, as I have put on the back of this paper, that we go back to that policy, essentially reversing this August 2021 policy. So that's my motion.
Could I have a second?
Second?
Any questions?
Do we?
Yeah, I have a question and I have a concern as well. This is Tracy Leonard.
Hey, Tracy, could you wait for a second and let Chief go?
Yeah.
All right. Okay.
Go ahead,
Sorry,
Tracy.
yeah, absolutely. I'm sorry, I couldn't hear him.
Go ahead.
Go ahead, Tracy. I'll defer to you.
Oh, thank you, Chief. I appreciate that. So the concern that I have is as an equitable one about access to records, and also whether the ADC is under the code section that Ms. Ashworth is referring to. Actually, the ADC wants to be identified as an entity for which the Commonwealth Attorney is then responsible for knowledge about everything in the ADC, as, for example, for Brady purposes. And so what I would really say is, because this is coming up at the jail board meeting for the first time, and I had not heard anything about this, I would ask that you defer any discussion about this until we've had a chance to look at it. I suspect that some of this has come up because there's been litigation in criminal cases where the public defender's office has not had access to records other than getting its subpoena duces tecum. And I don't know that for sure, but that's my guess. And as a result, I think that there are other issues and knock-on effects to this that we're going to result in more litigation going forward. And I think it needs more than just a vote brought up at the last minute like this, frankly, so that we can take a look at it more carefully.
Thank you, Tracy. Chief?
My question was similar, is do we know why the policy changed? Would be my question.
All right. I'm gonna make a couple comments about it, Chief, and I'm gonna come back to your question.
Okay.
This came up, and of course, our attorney, she's not here, she's on leave, and I would like to defer this until Ms. Pandak is here, because I think we all heard the certainly courtesy of addressing the board. Certainly we've heard from the common attorney, and I think we should hear from our jail board attorney, her position on this as well. What staff did, Ms. Pandak directed them to do that. So certainly, but my first suggestion was that Ms. Pandak meet with Ms. Ashworth and perhaps the public defender, and maybe they can work this out without it having to come before the jail board. I think, we do a great job making decisions about things, but this is an important issue. I may add, this issue came up one time when Mr. Ebert was the Commonwealth attorney, and we were able to work things out. And there's been some miscommunication with staff, and so we probably need to come up with a good policy, but I would like for our attorney to work with Ms. Ashworth and the public defender's office and see if they can resolve their differences on this, and then perhaps we can come back to the board if we want to discuss it. But that's what I like to do. And I know this is important to to Amy, because she and I talked today. If we need to have an emergency meeting after Ms. Pandak gets back in town and we can do this, I think, because I promised her today that I would mention that to the board, that because she said this is urgent, this is something that she wants to get done now, and I'm not going to disagree with her, but certainly if we can do that, I'm willing to do that. But I want to hear, I think the board should hear it from both sides. The attorney
I'm
sitting in
happy
for,
to try to work with Ms. Pandak and Ms. Ashworth to work this out, Sheriff. I think that's a great idea.
right, and of course, Ms. Pandak's, assistant is here tonight. Could you have any comments, sir?
I think that what Tracy mentioned, this came up. I think our concern whenever the policy was changed had to do with equity and fair access, and so I think that I agree with the sheriff that it would probably be best for a bit of a conference among the attorneys to try to figure something out, and then formalize something with a resolution by the board.
Mm.
No one else? Go ahead, Amy.
Yes, Ms. Lennox, can you hear me?
Yep, I sure can.
The litigation you're referring to, is that between the Commonwealth attorney and in a particular criminal case? You're not talking about litigation against the jail board, correct?
Oh, no, I'm talking, and I'm not even 100% sure about that, Amy. But I suspect that this came up in the course of a recent criminal litigation, some case, and there were issues raised and litigated, and the ultimate reaction was, to force Commonwealth attorney essentially to use the same route that the defense bar has to use.
And Zach, you were part of that involvement?
Mm-hmm.
That
In the research
don't
and
know
the
that-
decision making, yeah. Do you mean the litigation or?
No, you weren't part of the litigation.
No, yeah.
What Ms. Lennox is referring to is a criminal case that was
Right,
taking place in the.
And our records were involved.
And your
and the
records
ADC's
were.
records were
Yes.
part of that. Right?
And so you were fully involved in that issue?
If it's dealing with a certain motion to quash, yes.
A motion to quash, yes. Okay, and so you were familiar with it?
Yes.
And based on that, your involvement, you gave advice to the superintendent to stop our access?
We spoke. I didn't give advice to the superintendent to do that.
Were you present when the advice was given?
No.
You weren't?
I gave advice to Ms. Panday.
So you did the research and the advice and gave it to Ms. Panday, who gave it to Colonel Melitas?
Yes.
Okay. And as a result of that, Colonel Melitas, you issued those letters changing the policy?
Correct.
And cutting off our access?
Well, you still have access with a subpoena. We didn't cut you off completely.
Right. We have to file a subpoena, wait 14 days, and obtain access that way, right?
I'm following Ms. Pandak's direction.
Okay. And you, do you feel comfortable? Were you fully versed in this issue?
Yeah, I understood this issue enough to effectively advise Ms. Pandak. I spoke with some other attorneys around the state who deal with it in certain different ways as far as access by the defense bar.
And you said for you, this was an issue about equity and fair access. You mean between the Commonwealth Attorney's Office and defense attorneys?
Having equal access to the same information if they want it.
Okay. And in your analysis of that, did it play into your consideration that we are, in fact, a law enforcement department? We are part of the Department of Law Enforcement. Did you understand that at the time that you gave that advice?
Yeah, we did in the sense that you guys function different than, you're kind of a hybrid in the sense that you're law enforcement, but you go after the crimes as well. So that's where we ran into the issue of, is it fair for the inmates? Is it a due process question whether or not their info just kind of goes out versus to you guys just through the program versus the defense attorneys who don't have that same access. This was mainly a change to keep the ADC out of the middle of any records request issues.
In fact, it generates more record request issues for the ADC, doesn't it?
I mean, it depends.
Chief Newsom.
If I can ask the Commonwealth's attorney,
maybe the colonel, police officers can still get these records without a subpoena, correct? And is there any prohibition that you know of that prohibits police officers from sharing that information with the Commonwealth's attorney?
No.
Not that I know.
So this is essentially is creating an inefficiency, I guess for lack of a better word, because the police are going to have to do this now in lieu of the Commonwealth's attorney. I'm just asking if that's
Well, if it's an extra step now for the Commonwealth attorney,
that's an extra step for us.
for you
We're gonna have to,
to
we're
get
gonna
the
have to
stuff
pick up
and then ship
shell
it over.
records that they could otherwise have access to.
Right.
I just want to understand it.
And we're not against the defense bar having the same sort of access.
What was that?
I said we don't have a
Question?
problem with the. I'm sorry. We don't have a problem with the defense bar having equal access to it, the same way that the Commonwealth does.
The Commonwealth has access to all of the records, right? All of the inmates. Are you saying that the defense attorney should have access to all of the inmates?
No. And I'm not saying that you have access to all the inmate records either. I'm saying you have access to the inmate telephone calls, text messages, and let me see what's on the back. Calls and video visits. Yeah, it's that stuff, but not the like the discipline records and the classification records. We've always, as far as I know, I mean, it could have been done without our knowledge, but those sort of records are not open to the CA's office now. That wasn't my understanding that you guys had access to that stuff. I thought it was just the stuff that is mentioned in the summary.
If I could just be clear, defense attorneys are most concerned to have access to their own clients' records, not to everybody in the jail's records. We want access on the same basis the Commonwealth does to our own client's records if the client himself or herself does not object to that.
Oh, Mr. Torres?
I have a question. We work in we don't work in a vacuum. We work in a region. Is that the same policy that Fairfax and Arlington and Alexandria have in terms of the relationship between the information that the Commonwealth Attorney gets and
I think Mr. Kostelecki, you sent us a list of other localities. And
I didn't, I'm sorry, I didn't hear your response.
I'm sorry, Mr. Kostelecki sent us a list of folks. Oh yeah, you can. They treat it. The CA has open access in those, but.
If I may address that question, Mr. Torres, we did do a survey of the local areas. Stafford County provides open access. Fauquier County has direct access to inmate phone calls, video visitation. Loudoun County does not require subpoena duces tecum, provides everything to the Commonwealth Attorney's Office. Fairfax County, Chesterfield County, Bedford County, Floyd County, Greensville, York County, Grayson County, and Madison County are the ones that responded to our inquiries. Floyd County does require for each inmate that the Commonwealth Attorney fill out a form. Other than Floyd County, all of the others provide open access to the Commonwealth Attorney's Office, just as this detention center did prior to August 18th.
Do you know what the access for the defense bar was in those counties?
Tracy, I appreciate the defense wanting access to this, and perhaps if you want to bring that up on a separate motion, what I'm trying to establish is that the Commonwealth attorneys, as law enforcement, should have open access as we always have. We are different agencies, we have different missions, different purposes. Commonwealth attorneys have access to things in the Department of Forensic Science and other state agencies that private defense attorneys or public defense attorneys don't. And there's a lot that goes into that, but the prevailing practice is open access for the Commonwealth Attorney's Office because we're considered law enforcement. And, you know, this is a public safety concern. We have a case going on today that, as the prosecutor, it's a murder trial. Prosecutor came down to me and said, I hope you get this motion because one of the witnesses showed up with 2 gang members and was taking pictures of the detectives. And we're interested to know where that information goes. And we now don't have access to those records. And, you know, there have been occasions we have discovered people in the week before were smuggling drugs in through alleged legal mail. It was purporting to come from a lawyer, so it's not opened or scanned. But the prosecutors learned from listening to the jail tapes that's how they were smuggling drugs into the jail. And we had an overdose and a death this year from drugs being smuggled in the jail. So, you know.
No, nobody's saying that it's not useful for you, Amy. This is just about equity and fairness and transparency and the fact that ultimately the defense bar deserves access to their own clients' records without having to go through this community secrets process. And I don't mind talking through this. I just think that the way that this has been dropped into the middle of the jail board meeting today is inappropriate. And we should have known that this was coming up. I especially should have known this was coming up so I could be prepared to speak more clearly to this. And this is not saying that your job concerning public safety is not, maybe this is critical for you, but you could have found out that information without it being oh my gosh, if we can't have it tomorrow, then some horrible thing's going to happen and an inmate's going to die. Like, that is just drumming up a scenario that is rare and probably isn't addressed by this. I just don't think it's as dire as what you're painting here.
Okay, Rob Bailey?
Yeah, I have a couple of questions. Thank you, Mr. Chairman. Is it counsel's position that the Commonwealth Attorney's Office is not law enforcement?
No.
Okay. I was confused because you used the word hybrid, and so I was trying to understand that. So if the counsel's position is that Commonwealth Attorney is law enforcement, and the Commonwealth Attorney has correctly identified Section 15.2-1627 of the Code of Virginia, which allows for the access to these records, because
I'm sorry to interrupt, but I don't think that's what we're saying. That's not what that code section says. That code section simply identifies CAs as members of law enforcement. It doesn't give them access to the records.
Okay, so what does give law enforcement access to records?
That's what I was going to ask Ms. Ashworth. We haven't came across is there a specific code section?
The jail policy is what gives access to law enforcement.
Okay.
So
that leads, granted, I understand that. So it leads to my real confusion. When the chief of police for Prince William County asked if he, as law enforcement, or his force as law enforcement, was able to share the information with the Commonwealth Attorney, I think the answer was, yes, that's okay. So in effect, you're adding a step in there for the Commonwealth Attorney to get the access to these records as opposed to getting it direct. I don't understand that. Can you explain that, please?
it goes to the issue of equity and fair play. We want to be seen as equal in it, and that's the main reason why we don't want the unfettered isn't a fair word, but like open access to it versus the defense bar having no access to it. And there's not a good justification why the defense can't have access to their own client's information.
Yeah, so I don't know that anyone around this table or in this room would disagree with that, but isn't that a different issue? If we haven't had a public defender's office up until this past year, not sure what court-appointed defense attorneys or others were doing, But if there was a need, and we felt an equitable need to do that, isn't that a different? That's never happened when I was talking.
It's appropriate when the Reverend's talking that
Yeah,
you say,
right.
"Oh, Jesus."
So I guess I'm hearing, make no mistake, the president of the NAACP is all about equity, okay? Make no mistake. But I see this as two different problems or two different issues that have been conflated, and I don't understand it.
I guess I disagree in the sense that they're two separate issues. And I think of them as one and the same, as it's an access issue, and it just has to do with two separate parties. But it's information. It still has. To me, it's a question of equal access to information. I don't know. I get that it seems like an extra step, but at the same time, what about, I guess, the extra step for the defense? They still have to go.
Could defense attorneys get the information from the police?
No, I don't think so. Not the same way that. No, I don't think so.
Thank you, and I appreciate that. So Sheriff, Mr. Chairman, I'm done with my questions, but I do want to end with this statement. I see some inequities being imposed upon the Commonwealth's attorney as they try to do their job in their portion of public safety. I disagree that we should defer this matter any further, and I am in favor of voting on, if this is a proper motion, I'm in favor of voting on that motion this evening.
Okay, all right, Chief.
To clarify the attorney's statement, I want to make sure that I heard them correctly, what you were explaining. It would be jail policy that would allow the defense attorney to freely have access to their client's recorded phone call only. So if the client gave written permission for the defense attorney to have free access, that could take care of that equitable issue. And this is separate. This gives Commonwealth attorney free access. So it wasn't a legal decision. It's a policy decision based upon what the Reverend said, is that the Public Defender's Office is also a brand new office that we're just incorporating. Is that a fair statement? And does that address the equitable issue?
I think part of the equity question was it's about knowing what information has been disclosed. So it's letting the defense bar either know what has been turned over, or because they would never know what would be given over, but for basically like a Brady exchange.
Okay. Part two of that is then, if we've identified the Commonwealth attorney as law enforcement, and as the chief said, our staff can already get it, they're already getting it. All she would have to do would call us up, tell us what they want, and then, as the chief pointed out, then we have to send staff over to get it, correct?
That's assuming they don't go through the STT process.
Right.
Okay.
I think the.
If I can just say, what Chief Keen is saying, that would address it for us, Chief. Like, that's the issue, is we just want to have access to our own clients' records. And right now we don't. And so that would address it from our perspective.
I think the police department has access to the information right now, Pete, without having to come over here, correct?
That's correct.
Okay.
I'm sorry, I did have it. It would seem to me that well, I just want to make this statement. If there were a motion, a separate motion that was made to provide the access to these records that the public defender is talking about, I would be in favor of that one also.
So I'm troubled by the proposition that we table this and not vote on it today. And part of that, the rationale behind that being, well, it was just sprung on us today because we were not consulted when this policy change was made. And I understand that the board shouldn't be involved in the day-to-day operations of the jail. I'm not looking for that. But this is a significant policy change with legal ramifications brings me to a question that I've never had until today, which is, does your law firm represent the jail or does it represent the jail board? Are we looking to you for advice as the board on how to proceed, or do you represent the people who work at the jail and you're advising them, and we're could be considered an adverse party at this point, where we have a member of this board who has opposed your advice, and now we're looking at taking a vote on going against the jail or the jail board's lawyer's advice. I'm not clear anymore who you represent.
We represent the jail board.
But you've advised the jail outside of the presence of the jail board. Do you do that regularly?
Regularly, yeah. We are advised on the day-to-day, or we're questioned a lot of the time on the day-to-day operations of the jail. Because we also defend the employees of the jail.
So if we were to table this today for more discussion, it would be your firm talking to the jail board and advising us on what we should do. Like we're doing right now.
In the sense of advise we would make a recommendation, and then as a board, just like I guess with any client, you can choose not to follow it and do what you want to do.
And your recommendation is that we don't revert to the old policy, that we essentially say we are in support of this change that's already happened, even though we weren't involved in it.
So I think that we would be happy with, as long as the defense bar has access, the access that they need and that they want, and that they just straight up require, we would be fine with going back to how the CA had it before.
So your advice to us as the jail board is either both get access or no one gets access, but it's one or the other.
Yeah, that's right.
That answers my question.
I appreciate that, and I don't want you to think that I oppose the defense attorneys getting access, because I don't. Very often, we get 2 copies of the calls, and we provide a copy to the defense bar anyway. But my question is, where is that advice coming from? Is there a code section? Is there a case? Is there anything? Or is this just, this is my gut feeling that that's what's fair and right?
I would have to go back and look at the specific research. I don't know about. I don't think there's a case that says it's right, but there's also not. What the problem that we ran into was whether or not there's a code section that mandates it, and I think the problem we were trying to prevent here was issues with just stuff being turned over without knowledge of the other side. And it was really just, it was a policy issue to try, I think there was justification for it in the sense of having equal access, among other things. But it was to try to prevent issues with stuff being turned over on one side, not knowing what had been turned over, and so on and so forth.
Thank you. You appreciate that the police turn things over to us all the time that don't necessarily get turned over to the defense.
Right.
Like that's.
Mm-hmm. Yeah.
Yes, sir.
Make an amended motion. Make a motion that we proceed with a vote with the Commonwealth Attorney with further direction that within the next 30 days, the attorney, Ms. Pandek, meet with Ms. Lennox and the Commonwealth Attorney for them to discuss that side of it further, and then report back to the jail board. Is that?
I'm not sure that we need to be part of that.
Just trying to give you an opportunity to voice any concerns you would have to me.
Chip, why don't we vote on this motion and ask Tracy to come to the next meeting of the jail board with a motion to talk about, discuss the access to the defense on that, and not mix those two things.
That works for me as well.
And I think that Tracy can come with a motion of the type of access that they want, and then we'll discuss that. And when those 2 motions are disposed of, then we'll have your complete equity thing worked out. But I don't think that it's equitable. Like if I don't get it, you don't get it. That seems like impossible.
I think that we have to see things as they are. If there's an inequity, then let's work at it, but let's get the Commonwealth Attorney back where they were, and then we'll deal with the defense bar needs for access. And we can do that in our next meeting. If Tracy it can bring us, a motion to that effect, because this is all policy. So because it is policy, we can go either way and any way as we understand we should go. But I think that we should vote on, there's a motion on the table, seconded, and I think that we should vote on it.
No more questions? I guess we can vote on, Ms. Ashworth, is there any part of your motion you want to repeat to make sure everyone understands what you're asking for? Because you didn't read the whole motion.
I guess the therefore.
I'm happy.
Yeah, I was good reading the therefore.
The therefore be it hereby resolved that law enforcement as defined by 15.21627 of the Code of Virginia, which includes the Commonwealth's attorney and her assistant, shall be granted access to the records and recordings described in this motion by requesting same from the designated employee of the Prince William County Manassas Adult Detention Center and shall be provided same forthwith with and without delay.
And this is non-privileged information.
This is all non-privileged information.
You've heard Ms. Ashworth's motion, and we have discussion. Now it's time to call the roll.
Ms. Ashworth?
Yes.
Mr. Austin?
Yes.
Reverend Bailey?
Yes.
Ms. Clymer? Mr. Hatcher?
Yes.
Shelley Cleveland is absent. Sheriff Hill?
I vote yes.
Chief King?
Yes.
Ms. Lennox?
I'm going to vote against because I disagree with the way this was brought, and I think they should be dealt with at the same time. Thank you.
Mr. Torres?
Yes.
Mr. Newsom?
Yes.
Ms. Smith?
Yes.
Eight yeas, 1 nay.
Thank you. So on the motion that anytime the Commonwealth Attorney wants some information from the ADC, you give them the information.
I understand.
All right.
Mhm.
We'll get with you and Ms. Pandak and we'll draft the policy.
Yep.
And we'll bring that policy back to the board so the board can review it. All right. That understanding, Chief, that we talked about the story?
Yes.
Right. At our next meeting, that we will discuss the same issue again. Are we done? Want to make sure everybody understands.
Yes.
But this policy is in effect now,
Right. Mm-hmm.
and then we'll get the.
Right. Okay. So we'll get with her.
Okay.
All right. Thank you. Move right along to the next member, Ms. Smith.
We went a little more off track than I expected, but I wanted to offer to Cozy and anyone else on the board who would like to learn more about the circuit court drug court that we are developing. Of course, Steve has maybe even more knowledge than I do because he's implemented these before, but I know we're both happy to share with you the ideals behind it and how we're moving it forward and on what kind of timetable we're moving it forward.
And I will pick you up on that.
All right. Steve, did I call you?
You already did.
All right. Captain? Fine. All right. Reverend Bailey?
Yes. I have a motion in the form of a resolution. A little bit of preamble. We've talked in this board and continue to ensure that all of our staff here, and especially sworn staff, are adequately compensated for what they do. And we kicked around the idea of some hazardous duty pay. So with that, whereas the Prince William-Manassas Regional Adult Detention Center has a total of 350.4 full-time FTE sworn staff members, which is a total of 348 full-time and 4 part-time staff. And whereas the correctional work environment is inherently dangerous, requiring staff to maintain high awareness for extended periods of time. And whereas the congregate living conditions at the ADC require frequent direct contact, exposing staff to both health-related conditions and physical injury. And whereas beyond the risk of physical injury, there are extraordinary stressors associated with corrections work that can seriously affect the well-being of staff. And whereas the ADC has experienced an unprecedented amount of staff turnover, and whereas other jurisdictions are attracting staff with incentives, such as higher salaries and hazardous pay. And whereas equivalent hazard pay would be paid at $3,000 per year for a full-time sworn employee and $1,800 per year for part-time employees for a total cost of $1,051,200. And whereas the county is currently in the process of accepting budget requests for fiscal year 2023, and whereas the Regional Jail Board desires to provide hazard pay to assist with sworn employee recruitment and retention, now therefore be it resolved that the Prince William-Manassas Regional Jail Board does hereby approve to submit a fiscal year 2023 budget request to the Prince William Board of County Supervisors to fund ongoing hazard pay for the sworn staff of the Adult Detention Center. And so, Mr. Chairman, again, my motion is that the Prince William-Manassas Regional Jail Board does hereby approve to submit a fiscal year 2023 budget request to the Prince William Board of County Supervisors to fund ongoing hazard pay for the sworn staff of the Adult Detention Center.
Can I get a second?
Second.
Any questions? Sir, could you call the roll, please?
Ms. Ashford?
Yes.
Mr. Austin?
Yes.
Reverend Bailey?
Yes.
Mr. Hatcher?
Yes.
Sheriff Hill?
Yes.
Chief King?
Yes.
Ms. Lennox?
Yes.
Mr. Torres?
Yes.
Mr. Newsom?
Yes.
Ms. Smith?
Yes.
All vote yes, sir.
Thank you, thank you.
Thank you.
I think the staff really will appreciate that. It's gonna be tough because we have to compete with other agencies within the county. But I think the superintendent, and I do all I can to work with him, to try to get that through, all right? Thank you. Next item on the agenda is adjournment. Could I get a motion to adjourn?
Make a motion to adjourn.
A second.
All right, any questions? All in favor?
Aye.
Thank you.
New ordinance on that.
I will.